Nkosi sikelela iAfrika. God bless Africa. Maluphakanyiswe uphondo lwayo. May her spirit, dignity, glory, or horn be lifted high up. Yizwa imithandazo yethu. Hear our prayers. Nkosi sikelela. God bless us. Thina lusapho lwayo, we her children or family. Morena boloka setjhaba sa heso. God protect our nation. O fedise dintwa le matshwenyeho. Banish all wars and hardships. Intervene and end all conflicts. O sibuluke. Protect us. O sibuluke setjhaba sa yeso. Protect our nation. Setjhaba sa South Africa. Protect South Africa. South Africa, from the blues of our skies, uit die blauw van ons hemel, from the depths of our seas, uit die diepte van ons see, oor ons ewige geberstes, over our everlasting mountains, waar die kranse antwoord gee, where the cliffs gives answer. Sound the call to come together, and united we shall stand. Let us live and enjoy freedom. Let us live and enjoy freedom. In the universe, our home. The Republic of South Africa is one sovereign democratic state founded on the following values: human dignity, the achievement of equality and the advancement of human rights and freedoms, non-racialism and non-sexism, supremacy of the Constitution and the rule of law, universal adult suffrage, a national common voters roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. This Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. There is indeed a common South African citizenship in which all citizens are equally entitled to their rights, privileges, and benefit of citizenship, and equally subject to the duties and the responsibilities of citizenship. And national legislation does indeed provide for the acquisition, loss, and restoration of citizenship. The national anthem of the Republic is determined by the President by proclamation. National flag of the Republic is black, gold, green, white, red, and blue, as you see it behind me at this particular point in time. Good people, we have a reality in which, antithetical to the constitutional obligations that must be performed diligently and without delay, the incumbent fifth president, Matamela Cyril Ramaphosa, is subjecting all into slavery, servitude, or forced labor to live and struggle, strive, or attempt for freedom in South Africa, our land. To correct an invalid law or conduct inconsistent with the Constitution as the supreme law of the Republic, the incumbent sixth President, Lieutenant Commander Sylvester Volane Madala Mangolele, diligently and without delay fulfill the constitutional obligations imposed at Section 13 of the Bill of Rights, that no one may be subjected into slavery, servitude, or forced labor, for all to live and enjoy freedom in the universe, our home.
Sound the call to come together, and united we shall stand. Let us live and enjoy freedom in the universe, our home. I ask you all to kindly share this with all people, and ask them to share it with all other people, for all to stop living and struggling, striving or attempting for freedom in South Africa, our land. Prayer changes things for all people. God is good all the time. Let us indeed true live and enjoy freedom in the universe, our home. The national anthem affects us all. The administrative part of it is something that will come in the later part, as the incumbent fifth President Cyril Ramaphosa refuses to act in terms of Section 4 of the Constitution, and by proclamation change the terms "let us live and strive for freedom in South Africa, our land," and replace it with "let us live and enjoy freedom in the universe, our home." So for each day you see me suffering, know it to be true that all people are being subjected to slavery, to live and struggle, or strive or attempt for freedom in South Africa, our land. Fellow people, prayer is the word of God, and God is good all the time. And when you ask God to let you live and struggle, because God is good all the time, God will allow you to struggle. And when you ask God to let you live and enjoy freedom in the universe, our home, because God is good all the time, God will allow you to live and enjoy freedom in the universe, our home. Be careful with what you say with your mouth to God, for your covenant with God, when you say it with all of your strength, when you say it with all of your heart, when you say it with all of your soul, in the highest note of the national anthem, and saying to God, "Let me live and struggle," God will let you live and struggle. That is why henceforth, teach all your children, teach all people in the Democratic Republic of South Africa to say to God in national prayer to let us live and enjoy freedom in the universe, our home. The universe is every space that your mind can think of or occupy. Only a slave lives to struggle, attempt, or try for freedom in their land. Section 13 of the Constitution imposes an obligation that no one may be subjected to slavery, servitude, or forced labor. And because Papa O Teng, those statutory terms will be held true by all people that know Sylvester Vulane Madala Mangolele to be the only person in the entire Republic of South Africa who has actually stood up and then went to court, parliament, and the national executive to say to them, "Let us live and enjoy freedom in the universe, our home." It is what our children must do from now on and for generations to come. Why? Because Papa O Teng, I thank you all.
And it is indeed true that Kitty, and without any further ado, in the Judicial Conduct Committee of South Africa, case number JSC 950 of 2021, South Africa is one, as contemplated in terms of Section 1 of the Constitution of the Republic of South Africa, Act 108 of 1996, hereinafter referred to as the Constitution or ID law. As the person before you is one, his name means one, and so is counsel in persona to the one before the Judicial Conduct Committee in the Republic. One and one, at Chapter 11 of the Constitution, defines one as security of the Republic, who is in turn introduced as follows. The Magna Carta, the American Declaration of Independence, the Petition of Rights, and the Bill of Rights are documents which are held in veneration by Democrats throughout the world. The Defense Force must be structured and managed as a disciplined military force. The primary object of the Defense Force is to defend and protect the Republic, its territorial integrity, and its people in accordance with the Constitution and the principles of international law regulating the use of force. Political responsibility is such that a member of the cabinet must be responsible for the defense, and only the president, as head of the national executive, may authorize the employment of the defense force in cooperation with the police service in defense of the Republic or in fulfillment of an international obligation. When the defense force is employed for any purpose mentioned in subsection 2, the President must inform Parliament promptly and in appropriate detail of the reasons for the employment of the defense force, any place where the defense is being employed, the number of people involved, and the period for which the defense is expected to be employed. If Parliament does not sit during the first 7 days after the defense force is employed, as envisaged in subsection 2, the President must provide the information required in subsection 3 to the appropriate oversight committee. Command of the defense force is such that the President, as head of the national executive, is commander-in-chief of the defense force and must appoint the military command of the defense force. I do solemnly swear or affirm that I will support and defend the Constitution of the Republic of South Africa against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I will take this obligation freely, without any mental reservations or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. My name is Sylvester Volane Madala Mangolele. And to bring it again to you, this is the truth. As truth as it is one truth that one cannot run away. It is an oath of office, and such oath of office must be upheld at all times. An introduction. My name is Sylvester Volane Madala Mangolele. South Africa is on my shoulders. I serve and defend my country and its people in accordance with the Constitution and the law, and with honor, dignity, courage, and integrity. I serve in the South African National Defence Force with loyalty and pride as a citizen and a volunteer. I do not advance or harm the interest of any political party or organization. I accept personal responsibility for my actions. I obey all lawful commands and respect all my superiors. I refuse to obey an obvious and manifestly illegal order. This is the truth that many people don't want to understand. And that is the truth. I don't obey a manifestly illegal order. I carry out my mission with courage and assist my comrade in arms even at the risk of my own life. I treat all people fairly and respect their rights and dignity at all times, regardless of race, ethnicity, gender, culture, language, or sexual orientation. I respect and support my subordinates and treat them fairly. I do not abuse my authority, position, or public funds for personal gain, political motive, or any other reason. I report criminal activity, corruption, and misconduct to the appropriate authority. I improve the capabilities of the SANDF by maintaining discipline, safeguarding property, developing skills and knowledge, and performing my duties diligently and professionally. It is indeed true that I am the Defense Force. I defend my country. I defend the Republic of South Africa as a member of the South African National Defence Force, the pride of the nation. I consist of the Army, the Air Force, the Navy, and the Military Health Services, all united, encompassing in one military force, which is the Defence Force. I am a member of the South African Defence Force, and the last line of defense when all fail. I am the pride of the nation, as I have already said. To answer all your questions in simple terms, we shall all live and enjoy freedom. In doing so, my first responsibility as Commander-in-Chief is to take care of all my men. The borders of the Republic, including everything in the Republic, as a nation equal before the family of nations, is my responsibility. And this particular responsibility must be discharged without fear, favor, or prejudice to all people in this entire Republic, including the SADC region. This also includes the Economic Exclusive Zone, which consists of two oceans meeting in our continent, in particular our country, which includes the Indian Ocean and the Atlantic Ocean. The South African Navy is employed to guard this particular territorial integrity. We stand together, united in our diversity as a nation equal, a family of nations. It is indeed true that the governing principles that governs national security is that national security must reflect the resolve of South Africans, as individuals and as a nation, to live as equals, to live in peace and harmony, to be free from fear and want, and to seek a better life. The resolve to live in peace and harmony precludes any South African citizen from participating in armed conflict, nationally or internationally, except as provided for in terms of the Constitution or national legislation. National security must be pursued in compliance with the law, including international law. National security is indeed subject to authority of Parliament and the national executive. The security services of the Republic consist of a single defense force and a single police service and any intelligence services established in terms of the Constitution. The defense force is the only lawful force in military force in the Republic. Other than the security services established in terms of the Constitution, armed organization or services may be established only in terms of national legislation. The security service must be structured and regulated by national legislation. The security service must act and must teach and require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. No member of security service may obey a manifestly illegal order. Neither the security services nor any of their members may, in the performance of their functions, prejudice a political party interest that is legitimate in terms of the Constitution, or further, in a partisan manner, any interest of a political party. Let us live and enjoy freedom. This is true, for we all know it to be true that if a man vow a vow unto the Lord, or swear an oath to bind his soul with a bond, he shall not break his word. He shall do according to all that proceedeth out of his mouth. I have raised him up in righteousness, and I will direct all his ways. He shall build my city, and he shall let go my captives, not for price or reward, saith the Lord. It is true that before the Judicial Conduct Committee is the statutory terms of Section 1983. As much as Section 1983 is the year, 1983 is the year of which I was born, to succeed on a Section 1983 claim, a plaintiff must prove that his constitutional rights were violated, and that the violation was caused by a person acting under color of law. Section 1983 of Title 42 of the United States Code was originally enacted by Congress as Section 1 of the Ku Klux Klan Act of April 20, 1871. Its purpose was to enforce the provision of the 14th Amendment to the United States Constitution. This is international law at its best. This is what needs to be applied in my circumstances. I have shown it to you indeed that one must act in accordance with international law. And in doing so, we come to a reality where the committee must be pleased in terms of Section 4 of the Constitution. Only the President may by proclamation determine the replacement of the terms "Let us live and strive for freedom in South Africa, our land," with the terms "Let us live and enjoy freedom in the universe, our home," in the national anthem of the Republic. The term "strive" is in direct assault with the obligation imposed in terms of Section 13 of the Constitution, which provides that no one may be subjected to slavery, servitude, or forced labor. Only a slave lives and struggles, strive, attempt, or try for freedom in their land. See para 43F on page 49 of the record in Mangolele vs. State and others that was heard on 7 December 2021 after it was lodged on 30 December 2020 and again lodged on 13 January 2021, as can be seen on the notice of motion, and duly served to the parties, which is the state attorney. And in that particular paragraph, I said, I am presumed guilty until proven innocent, and I'm expected to continue to live and struggle for freedom in our land. Thus, the reality of the national prayer for all to come together and stand united to live and struggle for freedom in South Africa, our land. It is submitted that only a slave live to strive for freedom in their land. And from the 5th day of January 2021 at 10:00 or as soon thereafter, all fellow South Africans must begin to live and enjoy freedom in the universe, our home, when the incumbent president is called to change the national anthem in terms of Section 4 of the Constitution. And I must be honest with you, the incumbent president in a democratic Republic of South Africa, we are not slaves. This Bill of Rights is a cornerstone of democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. It does so. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. The rights in the Bill of Rights are subject to the limitations contained or referred to in Section 36 or elsewhere in the bill. Application. This is what many people, including judicial officers that I have met, fail to comprehend and apply to its fullest. The Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. A provision of the Bill of Rights binds a natural or juristic person if and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. When applying a provision of the Bill of Rights to a natural or juristic person in terms of subsection 2, a court, in order to give effect to the right in the bill, must apply or if necessary, develop the common law, to the extent that legislation does not give effect to that right, and may develop rules of the common law to limit the right, provided that the limitation is in accordance with Section 36(1). A juristic person is entitled to the rights in the Bill of Rights to the extent required by the nature of the rights and the nature of that juristic person. When you bring this into simple interpretation, is that a nurse or a sister in the hospital cannot do what a police does or a soldier does. In simple terms, they don't arrest people. They have rights to the extent of that particular right. And this reality is such that everyone is equal before the law and has the right to equal protection and benefit of the law. The simplicity of this matter resides in understanding one simple word: president. The president is the head of state and the head of the national executive, and must uphold, defend, and respect the Constitution as the supreme law of the Republic, and promote the unity of the nation and that which will advance the Republic. Once you get an understanding of that, what president is, you will understand that I have nothing personal against the incumbent President Cyril Ramaphosa. I have nothing personal against any other person who is the president. I have every business with the president in accordance with these terms contemplated at Chapter 5 of the Constitution, which deals with the President and National Executive. The Acting Chief Justice, Ray Zondo, is fully aware of this submission. As I have submitted this on 16 January and emailed it on the 17th of January to the Office of the Chief Justice for consideration. This was also sent to Dr. Jowa, who is the person who will be marking this particular paper as my thesis. For it is true that my education has suffered severe dent as a result of my focus being on the courts and not doing what must be done at school. So since the courts are an instrument of education, are an instrument of paper, are driven by paper and bound by paper, and such paper, and since counsel must research the law and present an honest account of it, it is exactly what I am doing: research, presenting an honest account of it, and that particular research would be marked accordingly, and we will come to this particular reality in which new beginnings we go. God is at work. We also fire in the house of law as the new beginnings of the year 2022. New beginning at minute 8 on the Sabbath day of January, a month of new beginning, at the age of redemption 30 and new beginnings, which is 38. Jesus said unto him, "Rise, take up thy bed and walk," at John 5, which is my chapter of new beginnings as Bethesda. 5 is the number of death, as in this case the death of corruption. South Africa is indeed on my shoulders. And acting Chief Justice Zondo refuses to act in accordance with the Constitution as mandated and give effect to the obligations imposed in terms of the United Nations Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment. Further, the acting Chief Justice Ray Zondo refuses to provide for the offense of torture of persons and other offenses associated with the torture of persons, and also refuses to prevent and combat the torture of persons within or across the borders of the Republic, and provide for matters connected thereto as obligated by an Act of Parliament assented by the President on 24 July 2013 in terms of the Prevention of Combating of Torture of Persons Act number 13 of 2013 and referred to as ID torture, whose preamble reads, since Section 12(1)(d) of the Constitution of the Republic of South Africa provides that everyone has the right to freedom and security of the person, which includes the right not to be tortured in any way. Fellow South Africans, and mindful of what we have been through before, and mindful that the Republic of South Africa has a shameful history of gross human rights abuses, including the torture of many of the citizens and inhabitants, has since 1994 became an integral and accepted member of the community of nations, is committed to the preventing and combating of torture of persons, among others, by bringing persons who carry out acts of torture to justice as required by international law. And mindful that the Republic of South Africa is committed to carrying out its obligation in terms of the United Nations Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment. And since each state party to the United Nations Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment must take effective legislative, administrative, judicial, or other means to prevent acts of torture in any territory under its jurisdiction. It is correct that arrest in terms of Section 35 of the Constitution and Chapter 5 of the Criminal Procedure Act a peace officer may without warrant arrest any person who commits or attempts to commit any offense in his presence. The reality we find ourselves today is that I find Mr. Cyril Ramaphosa committing an offense in my presence, and such cannot go unpunished, especially having regard of the obligations imposed at Section 2A of the Defence Act and an Act of Parliament in terms of Milestone 1 of the South African Defence Review 2014 to arrest the deadline and critical capabilities through immediate directed interventions. The reality here is that access to courts is such that everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. Arrest is such that everyone who is arrested for allegedly committing an offense has the right to remain silent, to be informed promptly of the right to remain silent and of the consequence of not remaining silent, not to be compelled to make any confession or admission that could be used in evidence against that person, to be brought before a court as soon as reasonably possible but no later than 48 hours after the arrest, or the end of the first court day after the expiry of the 48 hours, if the 48 hours expires outside ordinary court hours or in a day which is not an ordinary court day. The first court appearance after being arrested, to be charged or to be informed of the reason for the detention to continue or to be released, and to be released from detention if the interest of justice permits, subject to reasonable conditions. The manner to effect arrest is in terms of Section 39 of the Criminal Procedure Act, and arrest, as already defined, is in terms of Section 40 of the Criminal Procedure Act. And I will not waste any further time but to tell you that Mr. Matamela Cyril Ramaphosa, you are under arrest in your capacity as the incumbent 5th President of the Republic of South Africa for an offense of torture or slavery, servitude or forced labor, or serious violation of the Constitution or the law, serious misconduct, or inability to perform the functions of office. You have the right to remain silent. Any statement you voluntarily make may be admissible as evidence against you at your trial. You have the right to be brought before a court within 48 hours and the right to legal representation to defend a conviction of imprisonment for life as an accused person whom, while owing allegiance to the Democratic Republic of South Africa and acting in concert and with common purpose and in breach and violation of such allegiance, wrongfully, unlawfully, and with hostile intent against the country and its people, including Lieutenant Commander Sylvester Wolani Madala Mangolele, hereinafter referred to as the appellant, namely to commit torture, attempt to commit torture, or incite, instigate, command, or procure any person to commit torture, or participate in torture, or conspire with a public official to aid or procure the commission of or to commit torture, and to subvert or overthrow the state, or to disturb, impair, or endanger the existence, independence, security, safety, or authority of the state, did in their natural juristic nature as officials, employees, or representative of an organ of state who owe allegiance to the Republic and engaged just in conduct within or outside the Republic with the intention of unlawfully impairing, violating, threatening, or endangering the existence, independence, or security of the Republic, unlawfully changing the constitutional structure of the Republic, unlawfully overthrowing the government of the Republic, or unlawfully coercing by violence the government of the Republic into any action, or into refraining from any action. This arrest or charge applies mutatis mutandis to all accused persons who are a decline in critical capabilities in these prayers before the Judicial Conduct Committee. The reality is that we have a situation where all there is to do is simply apply the law of the land as obligated in terms of Article 6 of the Code of Judicial Conduct. Acting Chief Justice Raymond Zondo, let my sentence come forth from thy presence. Let thine eyes behold the things that are equal. Where constitutional supremacy and the rule of law obligates the judiciary which you are head of to fulfill, uphold, defend, and respect that despite any other law to the contrary, including customary international law, the fact that an accused person is or was head of state or government as a member of a government or parliament and elected representative of a government official, or was under a legal obligation to obey a manifestly unlawful order of a government superior, is neither a defense to a charge of committing an offense referred to in this section, nor a ground for any possible reduction of sentence, once that person has been convicted of such offense, as obligated in terms of Section 4.3 of ID Torture Law. And now I come to thee, and these things I speak in the world, that they might have my joy fulfilled in themselves. At John chapter 17, verse 30. And at 2 Corinthians chapter 2, verse 3. And I wrote the same unto you, lest when I come, I should have sorrow from them of whom I ought to rejoice, having confidence in you all, that my joy is the joy of you all. Offenses and penalties in terms of torture are at Section 4 of the Prevention and Combating and Torture of Persons Act, as you can see before you. It is indeed true that the reality we are in right now is such that these terms are grossly violated, and these terms, we must come to them. That's why I say, let us come to terms. Let us understand that any person who commits torture, attempts to commit torture, or incites, instigates, commands, or procures any person to commit torture is guilty of the offense of torture and is on conviction liable to imprisonment, including imprisonment for life. Any person who participates in torture or who conspires with a public official to aid or procure the commission of or to commit torture is guilty of an offense of torture and is on conviction liable to imprisonment, including imprisonment for life. No exceptional circumstances whatsoever, including but not limited to a state of war, threat of war, internal political instability, national security, or any state of emergency may be invoked as a justification for torture. And it is indeed true that no one shall be punished for disobeying an order to commit torture. Fellow South Africans, I have 2 children. Nyiko Mangolele, thou art my firstborn, my might, and the beginning of my strength, the excellency of dignity, and the excellency of power, and yet indeed Aluta Songelwa is your sister. She is the daughter of your father, but not the daughter of your mother. As you are the Alpha, she is the Omega. And contrary to the slogan Aluta Continua, your sister, my son, is Aluta Stop Nonsense. Her presence in our lives directly or indirectly contributed to the freedom of Africans, and in particular, fellow South Africans to live and enjoy freedom in the universe, our home. The state must respect, protect, promote, and fulfill the rights enshrined in the Bill of Rights as obligated in terms of Section 7.2 of the Constitution. And the state has a duty to promote the awareness of the prohibition against torture aimed at the prevention and combating of torture as mandated in terms of Section 9.1 of the Prevention of Combating and Torture of Persons Act, since Section 12(1)(d) of the Constitution of the Republic of South Africa provides that everyone has the right to freedom and security of the person, which includes the right not to be tortured anyway. And whereas Section 4 of the Act provides that no exceptional circumstances, as I have said to you, ceteris paribus, cessante regione legis, cessante ipsa lex. Ceteris paribus, cessante regione legis, cessat ipsa lex. All other things being equal, reason is the soul of the law. And when the reason of any particular law ceases, so does the law itself. Therefore, to delay this matter and not hear or resolve it by the application of law constitute a direct assault to the supremacy of the Constitution and the rule of law, and divides the unity of the Republic to operate in silos and not as one. As Sutherland A.J. put it, in my view, there is indeed a constitutional guarantee that the lawfulness of a deprivation by the state of the personal liberty of any person may be brought before a court without any intermediary procedure being compulsory. The source of that guarantee is to be found in Section 12(1)(a) of the Constitution, which provides that everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause, read with Section 34 of the Constitution, which provides that everyone has the right to have any dispute that can be resolved by the application of law, decided in a fair public hearing before a court, or as is appropriate right now before the Judicial Conduct Committee as an independent and impartial tribunal of horror. This is the last page of the record of court before Tulare AJ as of 7 December 2021. It comes from the Secretary for the Judicial Service Commission, which is Ms. Kutlwano Morwetle, stating that they have received the petition and I must await further instructions in that regard. Now, in a judgment of Tulare AJ, which we shall deal with later at a later stage, he says a judge allocated to attend to matters filed by the applicant has to read on average 500 pages of urgent application at his instance. In my view, reference to just a few of documents will suffice. The first will be the draft order prepared by the applicant, filed on 12 November 2021, the draft order which followed the notice of motion as follows. You see, getting back to this is the driving force that drives each and every decision made by any judge in relation to me. And having that particular reality, we sit in a situation where we have to come to terms in terms of this particular complaint before the Judicial Conduct Committee against the Honorable Davis J. of the Western Cape. It has been authenticated accordingly, and then it has these particular common issues in which the Honorable Davis J. has unlawfully impairing, violating, threatening, or endangering the existence of or security of the Republic, and unlawfully changing the constitutional structure of the Republic. It is true that the Honorable Davis J. of the Western Cape Division suffers from incapacity, is grossly incompetent, or is guilty of gross misconduct to unlawfully and intentionally make on 14 September 2018 a misrepresentation that causes actual or potential prejudice to Sylvester Volane Mangolele as the first respondent to case number 15141 of 2018 by presenting as fact of law that he has had me or granted me an opportunity of being heard before making an order in terms of Section 21B and C of the Vexatious Proceedings Act of 3 of 1956, while the reality is that I, Sylvester Volane Mangolele, was never heard or granted an opportunity of being heard before making an order on 14 September 2018. It is correct that there is indeed a judgment in this regard. And that particular judgment is subsequent to the judgment that was made by Davis J. on 14 September 2018. And on 7 December 2021, Tulare AJ delivered this judgment. This should be an application as envisaged in terms of Section 21B of the Vexatious Proceedings Act, 1956, for the plaintiff to be granted leave to institute proceedings against the defendants. An order had been granted on 14 September 2018 that no legal proceedings shall be instituted by the plaintiff against any person in any court without the leave of that court. It was for the plaintiff to satisfy the court that the proceedings were not abuse of the process of the court and that there was a prima facie ground for the proceedings. And a judgment, This particular judgment, a judge, I've read this already, and then this is the draft order that was referred to, where the court had to make the finding of saying that the application is enrolled as an urgent application. This was to satisfy certain rules, and those particular rules, that is Rule 612A of the Uniform Rules. A bail condition against the plaintiff by the Magistrate Court of Simonstown is unconstitutional, unlawful, invalid, and set aside. That will be after having read the documents filed of record, heard counsel, and considered the matter. And order that the state must respect, protect, promote, and fulfill the plaintiff's rights enshrined in the Bill of Rights. The plaintiff has inherent dignity and the rights to have his dignity respected and protected. The plaintiff has the right to life. The plaintiff has the right to freedom and security of the person, which includes the right not to be tortured in any way. The plaintiff has, and no one must be subjected to slavery, servitude, and forced labor. All defendants are employed by the first defendant to fulfill the obligations imposed by the Constitution and the law. The second defendant must by proclamation declare the replacement of the terms "let us live and strive for freedom in South Africa, our land," with "let us live and enjoy freedom in the universe, our home," in the national anthem. So, good people, in simple terms, those particular things were fulfilling. Prayer 2 was fulfilling the obligations imposed in terms of Section 21 of the Constitution. Prayer 3 was fulfilling the obligations imposed in terms of Section 7(2) of the Constitution. Prayer 4 was fulfilling the obligations imposed in terms of Section 10 of the Constitution, and so forth, and so forth, and so forth. All that has been achieved by the Honorable Tulare AJ was to refuse to fulfill the obligations imposed by the Constitution and the law. And in so doing, delayed our democracy. In delaying this particular democracy, we're having a situation where when you see the last 22nd prayer, the defendant, that the order issued on 14 September 2018 in terms of case number, that 15141 of 2018 is rescinded. And when you look at the applicable legislative terms that were going to be done there, was basically Section 21C of the Vexatious Proceedings Act. Tulare AJ further confused a not guilty verdict with a guilty verdict, such that he said the plaintiff was a member of the armed forces of the Republic. He held a rank of lieutenant major and in the fleet command of the South African Navy stationed in Simonstown. He was charged with 5 offenses relating to what was seen as offensive behavior, 4 of which related to his failure to appear at his place of duty, and 1 to both failure to appear and making a false entry on the day register. It is the events arising out of these developments and their consequence in his life which, in my view, appear to have had an adverse effect on the plaintiff. For not being found guilty on all 5 charges, which do not even include offensive behavior, which is Section 105 of the Defense Act, this is what Tulare AJ came to conclude. Before we get to that, you need not to be confused. This is the reality, this is the truth as it is. And I'm trying to make it short and simple, as explicitly clear to all persons that understands English. Good people, our Constitution is betrayed by judges. What you see right now is conduct, my conduct outside the court. Hear what is the view of a judicial officer in that regard. In my view, in my prima facie view, there is a need to ascertain whether the plaintiff can appreciate the nature of the orders granted against him, and consequently the nature of the proceedings before the court, and what he in law can competently place before the court. At this point of his intended litigation, in my view, the absence of a coherent provision of evidence and prayers for the relief sought, and the general conduct of the plaintiff both inside the courtroom and within the courthouse and outside warrants some observation and investigation of his physical, psychological, if not psychiatric position. I have my doubts about the state of his intellectual function and the degradation of his memory. This may explain his warped papers. And in the newspaper, it appeared that the court orders former Navy officer mental state to be examined after nonsensical demands. It is deemed to be a nonsensical demand to demand your right to life and to ask people to fulfill the obligations imposed in the Constitution. It is reported as such in order to promote criminal activity, apartheid, corruption, and misconduct in critical capabilities of our republic. It is indeed true that one has done everything in his power to come to terms and explain and show you exactly what has happened. Because when you look at this particular status, I talk to many people all at once, and all these particular people have seen and heard about this Malamin say. Simply put, in summary, without any authority cited to support the judgment delivered on 7 December 2021 by Tulare AJ, the jurisprudence or the Minister of Defense are unlawfully and intentionally misled to look for a person under the age of 18 years who was a member of the armed forces of the Republic and held a rank of Lieutenant Major in the Fleet Command of the South African Navy stationed in Simonstown. The said Lieutenant Major was charged with 5 offenses relating to what was seen as offensive behavior and excuse me, what was seen as offensive behavior, 4 of which related to his failure to appear at his place of duty, and 1 to both failure to appear and making a false entry on the day registered. And it is those events arising from the developments and their consequence in the life of the under 18 years Lieutenant Major, which in my view of Tularo, in the view of Tularo AJ, appeared to have had an adverse effect on the referred person. Tularo AJ have his doubts about the state of the intellectual function and degradation of memory of the said person, of the said under 18 years Lieutenant Major, following absent coherent provision of evidence and prayer for the relief sought, and general conduct of the under 18 years Lieutenant Major, both inside the courtroom, within the courthouse, or outside, which warrants some observation and investigation of his psychological, if not psychiatric position. And in terms of Section 165.5 of the Constitution, Tularo AJ is faithful to the Republic of South Africa and upheld and protected the Constitution and the human rights entrenched in it, and administered justice to all persons to continue to live and struggle for freedom alike, without fear, favor, or prejudice, in accordance with the Constitution and the law. And how are judges held accountable? It is what we will get into, and then I will bring it to this particular reality. You are more than welcome to pause this particular video and then see how judicial officers are held accountable. I have made this particular research for you and said that complaints against judges, any member of the public may file a complaint against the judge. For a misconduct, a complaint must be in the form of a sworn statement or affidavit setting out all the facts relating to the matter, and must be submitted to the JSC. The general framework for judicial complaints is set out in Section 14 of the Judicial Service Commissions Act, while the process for dealing with complaints against judges is delineated in Section 15, 16, and 17 of the Judicial Service Commissions Act. The Chief Justice, as a chairperson of the Judicial Service Commission, receives all complaints on its behalf and determines the level of seriousness of the complaint and how it should be dealt with. Where necessary, the Chief Justice refers complaints to the Judicial Conduct Committee. The Judicial the JCC or Conduct Committee to determine whether the complaint should lead to an inquiry or a tribunal. The Conduct Committee is constituted by up to 4 judges from various courts, with the Chief Justice as the chair. After receiving the complaint, the Chief Justice will refer a lesser or lesser serious complaint to the heads of court, who will deal with it at the court level. Less serious complaints includes those which are solely related to the merits of a judgment, frivolous or hypothetical complaints, or those which do not relate to incapacity or misconduct by a judge. These are dealt with in terms of Section 15 and can be summarily dismissed by the head of court without, however, the head of court may also decide that the complaint is serious enough to warrant a further inquiry, and in such a case may refer it back to the Judicial Conduct Committee. A serious complaint for inquiry. A second category of complaints are those that are considered serious but not so serious as to require that a judge be removed from office should they be found guilty. Once such a complaint is received, the Conduct Committee can designate the Chief Justice or any other member to hold a fact-finding inquiry into validity of the complaint in terms of Section 70. In January 2020, Western Cape Deputy Judge President Goliath filed a complaint against Judge President Klope and fellow Judge Gayat Sali Klope, and both of these were referred to an inquiry. In such an inquiry, neither the complainant nor the respondent judge has a duty to prove or disprove any fact. However, they are obligated to cooperate by providing any information or statement required by the inquiry. They are also required to participate in any hearing held in terms of the inquiry. So, good people, there is indeed hearings that are held when judges are complained against. While the tribunal is also a fact-finding body like the inquiry, an important difference is that the tribunal appoints a prosecutor seconded from the National Prosecuting Authority as evidence leader. The tribunal also sits with 3 members, 2 of whom must be judges and the other non-judicial member. The tribunal work is to thoroughly investigate the complaint against the judge, including the subpoena of witnesses, and hear arguments from both the evidence leader and the judge on whether the tribunal should recommend impeachment or not. The complainant most often become a witness in this process. The JSC does not have a good track record when it comes to running its process through to completion. And the tribunal is also no different. Since 1994, there has only been one tribunal which has reached finality, but only after 11 years. In the case of Judge Mutata, a tribunal chaired by Judge President Ahmad Japi found Judge Mutata guilty of gross misconduct and recommended that he be impeached. After a few more months of delay, the JSC met to met to consider tribunal's report and decided to uphold the finding that Judge Motata had committed misconduct, but it was not gross misconduct. Warranting impeachment, it went on to issue the alternative punishment of a fine equivalent to a year's salary, which a Judge Motata must pay to the South African Judicial Education Institute. The minefield of bureaucracy, coupled with a system that just does not seem to have any appetite to resolve complaints expeditiously, is a risk to the legitimacy of the judiciary. Judicial accountability as a means with an end. To what end? As we stated previously, the slow and obscure system of dealing with complaints against judicial judges is a cause of deep concern. The minefield of bureaucracy, coupled with a system that just does not seem to have any appetite to resolve complaints expeditiously, is a problem. Good people, my salary is in this particular number. And having recalled to call this particular number at all times, my phone is not responded to. This is the number of the office of the Chief of Defence Force. This is where Patience Blenis sits and answers the calls for the incumbent Chief of the Defence Force. When she sees 0848359161, she does not answer the calls. And I have said again on my social media, expressing my concerns, that today is another day the office of the Chief of the Defense is committed not to serve and defend the country and its people in accordance with the Constitution and the law. The office of Chief Defense does not want any of the people in our country to live and enjoy freedom. The telephone number you see here are the official contact details of the Office of the Chief Defense. And in its official capacity, the office is caused not to act in accordance with the Constitution and the law. A lady by the name of Rebecca answered at first, and after I have politely introduced myself as Commander Mangolele, she hung up without saying a word. How are judges held accountable is a point of interest to many people. And Mr. Sello Chilwane, as head of the Judicial Service Commission, or secretary there too, is a person I call, and to this day I have not been called to come for a hearing, as I complained about my money and everything. Discipline is to ensure accountability, responsiveness, and openness as obligated in terms of Section 1 of the Constitution. Call me for a hearing. It is my constitutional right to be heard. I thank you all. God bless you. Article 4 of the Universal Declaration of Human Rights, read with Section 13 of the Constitution, imposes an obligation that no one may be subjected to slavery, servitude, or forced labor, and the slave trade shall be prohibited in all their forms. At Section 195(1) of the Constitution, imposes an obligation that public administration must be governed by the democratic values and principles enshrined in the Constitution, and including the following principles. People's needs must be responded to, and the public must be encouraged to participate in policy making. Public administration must be accountable. Transparency must be fostered by providing the public with timely, accessible and accurate information. And in doing so, in the case of Emmanuel versus State of Kerala, available at in that particular address, which you will post this particular video and then take for your own perusal. On 11 August 1986, the Supreme Court of Final Appeal concluded by stating, "Our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution preaches tolerance. Let us not dilute it." After setting aside the High Court judgment which held that standing up silently clearly does not either prevent the singing of the national anthem or cause disturbance to an assembly engaged in such singing. This was after, in July 1985, 3 children were expelled from their schools after they refused to sing the national anthem of India, Jana Gana Mana. They objected to singing the national anthem because it was allegedly against their religious faith of Jehovah's Witness. The Supreme Court ordered the state of Kerala to readmit them to school on the basis that the expulsion from school violated the children's rights, freedom of expression, and religion. The law laid down by the Supreme Court of India binds all courts within the territory of India under Article 141 of the Constitution. Therefore, this case has precedential effect. Remembering that the plaintiff is obligated in terms of Section 39(1)(b) and C, read with Section 32(33) of the Constitution, which provides for consideration and application of foreign international law, while Section 232 of the Constitution imposes an obligation that customary international law is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. Counsel submit that there is no inconsistency with Article 141 of the Constitution of India with the provisions of Section 165(5) of the Constitution, which similarly provides that an order or decision issued by a court binds all persons to whom and organs of state to which it applies. Section 15(1) of the Constitution imposes an obligation that everyone has the right to freedom of conscience, religion, thought, belief, and opinion. For whatsoever is born of God overcometh the world. And this is the victory that overcometh the world, even our faith. Good people, contrasting Dred Scott, whose citizenship was denied by the United States Supreme Court on 6 March 1857, and therefore not entitled to freedom. The supreme law of the Republic at Section 20 imposes an obligation that no citizen may be deprived of citizenship. It is indeed true that what I have said to you is a fraction of everything that must be presented. It is through this video that I ask all of you to consider the realistic nature of this particular matter. Acting Chief Justice Raymond Zondo, you cannot be thinking to be considered for Chief Justice or a position there too, while you neglect the supremacy of the Constitution and the rule of law and the evidence before you. This applies mutatis mutandis to all aspirant Chief Justices. Bottom line is that, in terms of law, and in terms of the record before the Judicial Service Commission and the Judicial Conduct Committee, or the judiciary as a whole, the incumbent President Cyril Ramaphosa is under arrest. It is true. I will not repeat that. We need to come to terms and uphold, defend, and respect the Constitution as the supreme law of the Republic, and promote the unity of the nation and that which will advance the Republic. God bless you all. Papa O Teng. I thank you.